Okay, everybody, let's talk about updating research. And so the idea is to make sure to check the subsequent history of any case you want to use in a memo. And so here's a question. Let's say I have a case, Smith v. Jones, that I want to rely on for arguments in a memo or trial brief. What do I need to do? And the answer is check the flags. Red, yellow, green, no signal, plus sign, what signals, what flags am I looking at? And so Lexis has its symbols, so if you see red, you really have to think carefully about it. Yellow, there could be negative treatment, distinguishing cases. Now positive treatment, you probably say, okay, well that's good law, I can use it without any issues or as much to think about. And then the blue symbols are also, neutral. And Westlaw, red flag, yellow flag, you might have distinguishing cases or other negative treatment. And then this other flag that you'll see once in a while, case has been appealed to, let's say the 7th Circuit or U.S. Supreme Court. So, question. Let's say I have this plus sign flag or no signal for Smith v. Jones. Is it okay to use the case? And yeah, most likely. It's most likely good law. But it's often a good idea to read several cases on the issue that you care about and use Smith v. Jones if it's your preference. And that's sort of an overall theme here. Make sure to read a bunch of cases when you're doing a legal analysis. Next question. I found a red flag or stop sign for Smith v. Jones. Can I rely upon the case? Well, we're going to have multiple different answers, some of them conflicting because, hey, this is law school and it's my job to confuse you. So red flag, it might be a problem or it might be okay. So let's look at some possibilities. So again, red flag, what should I do? Answer number one, well, read the subsequent case law. If Smith v. Jones, if it's been reversed or overruled on the issue you care about, then don't rely on that case. It's not good law. And so you have to look at the subsequent history to find out. Answer two, likewise, if Smith has been superseded by statute. What I mean by that is if some statute was enacted after the Smith decision that changed the law and negates the whole analysis in Smith, then you can't rely on Smith because Smith is not good law. How about that? Answer three. Well, here's where it gets interesting. If Smith was overruled or reversed on an issue you don't care about, it might be okay to use it. It could still be good law on the issue of interest. And so I think it's definitely okay to use Smith if you see a bunch of later cases, maybe treatises citing Smith on that issue that you care about. Hey, if Smith is good enough for these later cases or for a well-respected treatise to cite to it on that principle, then it's probably good enough for you. Now, in your cite to Smith, make sure to include a parenthetical explaining it was overruled on other grounds. You want to show your reader you're aware that it was reversed or overruled on other grounds. And so I have an example here from a real brief. I just pulled a rule out of it. And my blue arrow points to overruled on other grounds. So Roe v. O'Donoghue is still good on this point that multiple defendants, all defendants must join a notice of removal. Okay. Actually, let me go back. If I pulled this out of a brief, but I'd probably want to check if I'm writing a brief today. I'd want to check, is this rule still good? And I'd look at Roe v. O'Donoghue. And I'd look at Murphy Brothers and I'd say, okay, as of today's date, is this rule still good? And I would shepherdize these cases, check the signals. Do they have, yellow flags or green plus signs or what's going on? Okay, so answer four, if there's an alternative to Smith, if I find some other case which is just as helpful, and I say, well, I found another case that hasn't been overruled, I'll just cite to that other case. And then that way I don't have to include this parenthetical that the case was overruled on other grounds. That's an option, something to think about. Next question. What if Smith v. Jones has a yellow flag or otherwise indicates some possible negative treatment? Well, answer one, Smith, it's still good law, most likely, but read the subsequent case law. Maybe Smith was distinguished by a later case. That could be okay, but think about whether the later decision supports some other argument that affects your analysis. So you want to know about distinguishing cases because it helps you to see other arguments. Next idea, what if Smith has been criticized by later cases, but not necessarily distinguished on the facts, but other later courts sort of criticize Smith? That could affect your analysis. So if you have a bunch of different courts saying, oh yeah, Smith v. Jones, has a questionable analysis, and Smith v. Jones is different from most of the cases you're reading, it's probably not going to hold up. It might not be the best case to rely upon in your memo. So some terminology, concepts, direct history. So prior and subsequent history of your legal authority, your case that you're looking at. Was this case that you're looking at appealed? Was it affirmed, reversed, remanded? Same thing with statutes. Do you have a statute that's reversed, amended, affected by pending legislation? That's different from indirect history or citing references. That's where you have listing of other cases, secondary sources that cite to your legal authority. So you could have a later case that overrules, criticizes, or distinguishes cases, secondary sources that merely cite to your case. So keep that terminology in mind. I'm sure you'll see it as you navigate on Westlaw or Lexis. So what about circuit splits? What if Smith is a federal case and there's a circuit split? Let's say the 7th and 9th circuits have a contrary position for the law on some issue. So the answer here, you need to think about how you want to use Smith. And let's focus on memo writing right now. We're not going to get to persuasive or trial brief writing for several weeks. So let's just think about memos and keep this simple. So some ideas for now. First of all, you want to be able to identify that there's a circuit split. Okay. Figure out the law in your circuit. That's really important if you're writing a memo. What's the law in my circuit? Does it follow Smith, or does my circuit contradict Smith? And so you want to accurately convey the controlling law when you're writing a memo. Now, next bullet, maybe your circuit has not yet taken a position on the issue. Okay, then maybe in my memo I point this out. In a memo, I might point out the split in the rules. Perhaps I use Smith or some other case. And there you go. Now, updating sources is really part of a broader theme of digging into the case law. So this broader theme, as an attorney, it's your job to figure out how the law has developed on the issue, figure out what the controlling principles are. So you need to read a variety of cases and pay attention to jurisdiction and so forth. Variety of cases on the issue so that you have the requisite expertise to deliver competent advice. And so it's hard work. You have to read a bunch of cases. But your clients are relying on you to get the law right and to see the potential arguments that are out there. And so again, final thoughts. Keep an eye out for your professor's guidance on assignments, emails, D2L content. And of course, if you inappropriately rely on a reversed or overruled case in a brief, a court may sanction you. And so in the spirit of the polar vortex, it reminds me of a song. The judge, he smiled as he picked up his pen. 99 years in the Folsom pen. 99 years underneath high ground. I can't forget the day I cited that overruled opinion in my trial brief. Thank you and stay warm.